Good evening, ladies and gentlemen. I'm Jerry Brown, Dean of the Journalism School, and I'd like to welcome you to this evening's address. I'd like to thank President Dennison and his staff, and especially I'd like to thank Professor Richard Drake, who's been the driving force behind the Presidential Lecture Series. Professor Drake has been an equal and equally enthusiastic partner with the School of Journalism in attracting tonight's distinguished speaker. Most of you know Anthony Lewis from print or from television, and you know he's a journalist of national and international distinction. Mr. Lewis is now in the most active semi-retirement I've ever heard of. He's writing long reviews for the New York Review of Books. He's teaching media law at Columbia. He's vegetable gardening, and his travels extend from Martha's Vineyard to Montana. I could not introduce Anthony Lewis without saying that he is a graduate of a small college near Boston on the Charles River, and that he has taught there and been a Nieman Fellow there. I also cannot avoid pointing out that he's won 2 Pulitzer Prizes for his work as a reporter for a Washington newspaper and a New York newspaper. He was New York Times bureau chief in London for 9 years, and thereafter he embarked on a career as a columnist for the Times that spanned more than a quarter century. Indeed, Anthony Lewis is considered by many experts in journalism, including me, as the lion of liberal columnists. And he acquired that title when members of both major political parties might wear the title liberal proudly. Resume facts garnered from Google hardly capture the influence of Anthony Lewis. In fact, that influence came home to me Sunday night as I was watching that progenitor of TV news magazines, 60 Minutes. In light of the visit of our speaker tonight, 2 disparate segments of that CBS program struck me as ironically connected. The first was a story on the continuing investigation into the murder of Emmett Till, a teenager from Chicago who was killed in Mississippi during the Civil Rights Movement. It brought back to my mind the political and social climate of the South when I was a student working on the campus newspaper. Journalism in those days in that region was dangerous, exciting, and in that land famous for rebellion, rebels against the established social and political order were considered at best upstarts and at worst turncoats. It was out of that political cauldron in my home state of Alabama that the famous case New York Times versus Sullivan arose. And it was Anthony Lewis who covered it for the Times, who wrote about it, and who this morning, 40 years after that famous decision was handed down, reflected on that case for our students, our faculty, and for many interested Missoula citizens. Now to the second segment of that 60 Minutes program. Steve Crofts interviewed Jon Stewart, a comedian and commentator whose specialty is caricaturing politicians and also the media for its coverage of politics. In his routine, Stewart skips over superficial facts, sometimes gets them wrong, to get to the deeper truths. What he says stings and it shames and it ridicules. And in a time before New York Times versus Sullivan, we might imagine that some public official might try to silence him by suing him for libel. But thanks to New York Times versus Sullivan, public officials would place a tough test if they tried to muzzle a satiric press by filing civil actions. It has been said that an editor, by definition, is a person who can write a transition between any 2 paragraphs. And I take the liberty of uttering this one. But for the press was what it was doing to protect its First Amendment franchise in the South of the 1960s, we might not today have had freewheelers like Jon Stewart, who are providing valuable reflections on the absurdities in both politics and the media. And but for Anthony Lewis, with his skills and intelligence to report and reflect on contemporary events, on history and the law, we would be less able to understand or appreciate these myriad connections. As one commentator has said, Anthony Lewis set the gold standard for covering and interpreting the actions of the U.S. Supreme Court. Moreover, his coverage resulted in 3 books, on individual rights, the courts, and the First Amendment. For many of us in the profession and in the academic community, Gideon's Trumpet and Make No Law are must-reads for students of journalism and jurisprudence. If I know Anthony Lewis, and I think this is the fourth time I've introduced him, he will say that my plaudits are well over the top. But if he does say this to you, I want you to mark it off as the mock modesty of a Boston Red Sox fan whose team is 2 games up in the World Series, and as I walked into this auditorium, was 2-0 in the top of the 4th. We're honored to have a man of Anthony Lewis's stature on the University of Montana campus. This morning we saw him in his role as reporter and expert on the First Amendment law. Tonight we will see Anthony in a different, if related role, that of an experienced, impassioned champion of that open, august, and robust debate, a phrase that defines what discourse should be in our democracy. Please join me in welcoming to the Presidential Lecture Series, Mr. Anthony Lewis.
Jerry, it's a pleasure to be introduced by you, a pleasure that's growing on me. But you stole my line. I was going to start by announcing the score, which I too had heard. Ladies and gentlemen, it's wonderful for me to be here with you in Missoula. You all have the good luck, or perhaps it's the wisdom, to live in this beautiful state. I'm fond of where I live, Massachusetts, but you know that Montana has special qualities. My subject tonight is a somber one. The title of my talk is Law and the War in Iraq. But I'm going to speak more broadly about what is happening to our law under the stresses of war, and that inevitably engages a larger reality, the meaning of law in an age when we have to deal with the phenomenon of terrorism. I do not have to dwell on the menace of terrorism. Its victims are well known to us. Russian children at school in Beslan, Israeli families vacationing across the border in Egypt, Americans at work in the World Trade Center. We know they will not be the last victims. Terrorism has been with us for centuries, from the Jacobins of revolutionary France to the anarchists in Joseph Conrad's great novel, The Secret Agent. But they are far more dangerous today. They have more powerful weapons. They are more numerous. They seem to be driven by greater zeal, and they are acting around the world. Whoever is elected President of the United States a week from today will have no more formidable duty than trying to take effective action against the terrorist threat. That is also true for political leaders in Europe and Asia and the Middle East. But when I said my subject was somber, I really meant something else. The reason for my concern is that in the fight against terrorism, we are straying from the path of the law. The temptation to do so is there in other countries too. But I think it is especially dangerous in ours, because more than any other country, the United States depends and has always depended on the supremacy of law, and has shown that light unto the nations. Law has defined the American political structure from the beginning. Without the intricate balance of state and federal power agreed by the framers of the Constitution at the Constitutional Convention in Philadelphia, and the separation of the federal government into 3 branches, the United States would not have come into existence. And without enforcement of the Constitution as law by the courts, this sprawling, unruly, fractious country would not have held together. Think about the way George W. Bush became president. When the Supreme Court decided the case of Bush against Gore 4 years ago, many Americans, I was one of them, thought the decision was unprincipled, indeed illegitimate. And after all, more people had voted for Gore than for Bush. Yet the decision was quietly accepted, and Bush entered the White House. Such is the hold of law and the courts on the American mind. We do not have ethnic solidarity in this country to hold us together, to which I may add, thank goodness. We do not have the romance of kings and queens and legend. We have the law. Or do we still? That is the question. After Abu Ghraib, can we still claim to be a nation that reveres the law? We've seen the photographs of our prisoners abused, humiliated, tormented. But we still do not know who was responsible for those outrages. I mean responsible not on the lowest level of enlisted American soldiers, but on the level of command and political responsibility. And I have to say that I do not detect any eagerness to find out. Moreover, we have barely begun to hear about another practice at Abu Ghraib, keeping the names of some inmates off the official roster of prisoners. Why? One mooted possibility is that the jailers wanted to hide those prisoners from inspectors sent to Abu Ghraib by the International Committee of the Red Cross. Another is that keeping them unregistered would make it easier to move the prisoners to sites outside Iraq, where they would not be given their rights under the Geneva Conventions. We know that at least one of those prisoners was killed in captivity. We've just learned that a secret Justice Department memorandum drafted at the request of the CIA told the CIA that it could take detainees out of Iraq to be interrogated. The memo appears to be a call for violation of the Fourth Geneva Convention, which forbids removal of persons from occupied territory. The memo came from the Justice Department's Office of Legal Counsel, which also prepared opinions justifying the torture of suspected terrorists. Excuse me, I'm just going to have a swig of water here. That culture of contempt for the law has grown since September 11, 2001. President Bush, Attorney General John Ashcroft, and others have used the threat of terrorism as a reason to override constitutional rights and violate treaties. I think they have effectively adopted the fatal doctrine that the end justifies the means, the totalitarian justification for official lawlessness. I do not mean that America has become a totalitarian society. Most of us go on about our lives as before. Those who have paid the price of this new view, new to America, of law as a mere instrument of power, have mostly, not entirely, but mostly been immigrants and foreigners, people without political influence. Thousands of them have been the victims of harsh, punitive action. But insistently, relentlessly, government officials have been laying down principles that can be used against anyone. In a dozen ways that they have argued that there are no limits on what a president can do in the name of national security. The king can do no wrong. A brazen example of disregard for legal commitments is the treatment of the prisoners held at Guantanamo Bay, Cuba. The Third Geneva Convention, which the United States signed and ratified, provides a system for deciding the status of people seized in a conflict. Is a captive a prisoner of war? Someone taken by mistake when he was innocently near a battlefield? A spy or terrorist rather than a legitimate soldier? The convention requires that such issues be decided by a competent tribunal. In the Persian Gulf War in 1991, American forces set up tribunals of their own officers who held hundreds of such Geneva Convention hearings. Most of the hearings ended with the tribunal deciding that the prisoner was wrongly held and should be released. George W. Bush decided to ignore the requirements of the Third Geneva Convention. He found on his own, without any hearings, that all of the prisoners held in Guantanamo were unlawful combatants, a term not found in the convention. And so, he said, they were not entitled to the convention's protections. A judge of Britain's highest court, Lord Steyne, said in a speech a year ago that the Bush administration's decision put the Guantanamo prisoners in a legal black hole. As a lawyer brought up to admire the ideals of American democracy and justice, he said, I would have to say that I regard this as a monstrous failure of justice. The Bush administration, moreover, took the position that the men held at Guantanamo could not go into American courts to petition for habeas corpus, the ancient writ that makes a jailer show the legal basis for a prisoner's detention. Lord Steyn said that under the administration's view, I quote, United States courts would refuse to hear a prisoner at Guantanamo Bay who produces credible medical evidence that he has been and is being tortured, close quote. When I read Lord Steyn's lecture, I thought there was no reason to believe that prisoners in Guantanamo were being tortured. That was before we saw the pictures of what was done to prisoners in Abu Ghraib. And now we have had a detailed story in the New York Times about the abusive treatment of prisoners in Guantanamo, shackling them to the floor hand and foot, and subjecting them to high-volume music, freezing air conditioning, and strobe lights for up to 14 hours at a stretch. The attempt of the Guantanamo prisoners to petition for habeas corpus in American courts finally went to the Supreme Court. There, the Bush administration took an absolute position. On this issue, it argued, what the president says is the law. Its brief was blunt. The president, it said, in his capacity as commander-in-chief, has conclusively determined that the Guantanamo detainees are not entitled to prisoner of war status under the Geneva Convention. In other words, justices, keep your hands off. But the justices did not. Last June, they decided that the Guantanamo prisoners could bring habeas corpus actions to challenge their detention. They could, in other words, make the government produce evidence before a court to justify their imprisonment. The Bush administration quickly took steps to keep that from happening. It brought a number of the Guantanamo prisoners to hearings before tribunals of American officers, more or less what would have happened if it had complied with the Geneva Convention in the first place. But by now, I think, the demand for a full legal process with lawyers for the prisoners is so strong that the government's tardy conversion to military hearings may not be enough. There were powerful warnings from inside the Bush administration that refusing to comply with the Geneva Convention was a bad idea. The State Department's legal advisor, William H. Taft IV, said compliance with the convention would show that the United States bases its conduct not just on its policy preferences, but on its international legal obligations. Colin Powell, the Secretary of State, sent a memorandum to the President warning that violating the convention would, quote, reverse over a century of U.S. policy and practice and undermine the protections of the law of war for our troops. But the White House counsel, Alberto Gonzales, told the President that he should ignore those objections, and he did. It is not only prisoners abroad who have felt the effects of official American indifference to the rule of law. Thousands of aliens in this country were rounded up in the weeks after 9/11 at Attorney General Ashcroft's orders on the theory that they might have a connection to terrorism, a theory without any grounds for actual suspicion. They were held for weeks and months under appalling conditions. In the Metropolitan Detention Center in New York, they were kicked, brutalized, held in solitary confinement with fluorescent lights on 24 hours a day, told they would die there. The Justice Department's Inspector General found what I have just said. His findings were that they were thus brutalized. He found that they had been unlawfully abused, and their families could not find out where they were. In the end, most were deported for such violations of immigration law as overstaying a visa. None were convicted of terrorism. Nor has the abuse of law been confined to aliens. Brandon Mayfield, a 37-year-old lawyer in Aloha, Oregon, was arrested last May for unstated reasons. He was held in total secrecy for 2 weeks. The Justice Department said only that he was being detained as a material witness, using a law that was designed to keep potential witnesses from fleeing, but that Attorney General Ashcroft has turned into a catch-all device for detaining people. Mayfield, we finally learned, was suspected of having a connection with the terrorist train bombing in Madrid last spring. The FBI said his fingerprints matched some found by the Spanish police investigating the train bombing. But the Spaniards told the FBI that there was no match of the fingerprints. In the end, the FBI admitted that it was wrong, and Mayfield was released. Arrested and held in secret with no chance to know what the reason was or to dispute it. Could that happen in America? It did. The Mayfield case shows how the usual protections of American criminal law, for one, the right to a hearing, have been drained of their meaning in what President Bush calls the war on terrorism. From the top of the government to federal prison guards in Brooklyn and federal prosecutors in Oregon, there is a culture of indifference to law. What I believe is the most dangerous example of bending law and the Constitution to the supposed needs of the war on terrorism is the claim by President Bush that he can arrest any American citizen, ladies and gentlemen, I can't see you through these lights, but now I can. It's any of you, assuming that most of you are American citizens. He can arrest any American citizen suspected of a connection to terrorism and imprison him or her indefinitely without a trial and without access to a lawyer. That claim has been pressed by the government in the cases of two Americans, Yasser Hamdi and Jose Padilla. Without any legal process, the president declared both of them to be enemy combatants. They were condemned to solitary confinement for years in Navy brigs, without, I repeat, the right to talk to a lawyer. Hamdi's father sought his son's release in a petition for habeas corpus. Last June, the Supreme Court, against the strongest advocacy by the Bush administration, decided that under the Constitution, Hamdi had the right to know the government's evidence against him and to challenge it in a proper hearing with a lawyer. The administration's response to that decision has been extraordinarily revealing. Rather than give Hamdi his day in court, as the Supreme Court intended, it decided to let him go home to Saudi Arabia, where he had lived, if he would agree to give up his American citizenship. He agreed. An agreement, I may say, that may not be enforceable should he subsequently desire to resume his American citizenship, since I don't think, and many lawyers don't think, that you can have your citizenship extracted under such circumstances when you don't really have a choice. So this man, who the Bush administration said was so dangerous that for years he could not even speak to a lawyer, is now suddenly free. And Attorney General Ashcroft, in announcing the decision, still referred to Hamdi as an enemy combatant, the claim that Ashcroft had never been willing to submit to the process of law. After the Abu Ghraib scandal broke, the press ferreted out memoranda that Bush lawyers at the Justice and Defense Departments had written on the subject of torturing prisoners in the war on terror. The memos argued that the president could order the torture of prisoners even though it is forbidden by a law passed by Congress and by the International Convention Against Torture. An Assistant Attorney General, J.S. Bybee, wrote that any law interfering with what he called the president's direction of such core matter as the detention and interrogation of enemy combatants would be unconstitutional. Bybee is now, by President Bush's appointment, a judge of the United States Court of Appeals for the Ninth Circuit. I think the Bush lawyers who make such arguments cannot be called conservatives. They stand for radical change in the deepest of American traditions, the one that John Adams defined in his statement that we have a government of laws, not men. Historically, the conservative position has been to warn against concentration of power in the presidency, to insist on respect for the states and for the other branches of the federal government. Those who mislabel themselves today as conservatives want to have a presidency essentially unconstrained by law. They see law as a mere instrument of power. The other day, I had a reminder of how sharp a change we are seeing in the American tradition of law. I was at a memorial service for Archibald Cox, the the lawyer and law teacher who, as a special prosecutor, dug for the truths of Watergate and insisted that even a president, President Nixon, must comply with the law. At that memorial service, the dean of the Harvard Law School, Elena Kagan, said she was too young to have known Archibald Cox, but he had taught her a crucial lesson. His life, she said, I quote, stands for the primacy of the rule of law, the practice of resolving disputes by common norms rather than by power and violence. Archie Cox personified that value. He taught not just me, but a nation, that it would be strong only to the extent that law was its foundation, only to the extent that law was respected above all. Close quote. It is an American idea that everyone is accountable to law, presidents as much as ordinary citizens. Law pervades military as well as civilian life, by the way. I recently met a Marine colonel who's a lawyer and who has been assigned by his superiors to be the lawyer for one of the defendants, one of 4 defendants who have been charged before a special military tribunal in Guantanamo with crimes of war. He was as eloquent in defending his client as any civilian criminal defense lawyer would be, and as eloquent in attacking as unfair the tribunal rules established by President Bush. His position was a straightforward one. He said, in the military, we believe in law. We have a legal system. We think it's very important for our protection as well as for the country that we comply with the law and that the law stands firm. As a people, we have found our safety in law, in the belief that law will protect us from that common failing of governments everywhere, abuse of power by those who hold office. In our confrontation with terrorism, the great challenge is to maintain our commitment to law, above all to the protective rules of the Constitution. If we abandon those rules, if we say that fighting terrorism justifies any means, then we will have lost what makes America special. In the novel about terrorism that I mentioned earlier, Conrad's The Secret Agent, an anarchist bomb maker tells his colleagues that their aim should be to break up the superstition and worship of legality. Until the middle of the 20th century, the United States stood alone. 50 years ago, 55 years ago, the United States stood alone in having a written constitution whose rules were enforced by judges. Other democratic societies relied on the good faith of elected officials and on public opinion to prevent abuse of power. But the experience of the Nazis and the Holocaust persuaded other countries, many of them, that rules were necessary. Since World War II, countries around the world have copied the American model. France, the epitome of centralized power, has a constitutional system now. Germany has a written constitution and an outstanding constitutional court. India's courts have held the government to constitutional rules. South Africa, in breaking from its racist past, adopted a stringent Bill of Rights and a strong constitutional court. I'll interrupt myself and interject that one of the great moments in the new South Africa came when the new constitutional court held that Nelson Mandela, the first president of a democratic South Africa, had violated the rules of the Constitution in setting up an election in part of the country, the Western Cape. And within an hour of the court's decision, President Mandela went out on his balcony and said, "This is a great day for the new South Africa. The court has told us what the law is, and we're going to comply with it. That's the new South Africa." That's the way I think it ought to be. Even Britain, which for so long made the supremacy of Parliament an article of faith, has made the European Covenant on Human Rights binding on its courts. It would be the greatest of ironies and the bitterest if we Americans abandoned the constitutional faith that has inspired so many others. Moreover, it was Americans who in large part created the very concept of international human rights. The United States Congress, decades ago, began demanding that countries receiving U.S. aid live up to basic standards of humanity. American constitutional rights, guarantees of due process, free speech, the right to counsel became international ideals. That enlightened leadership seems now to belong to another age. The United States is best known today in human rights terms for its single-minded opposition to the new International Criminal Court created to bring the authors of genocide and other war crimes to justice. Leaders of the law in Britain and elsewhere in Europe share Lord Staines's outrage at the attempt to hold the prisoners in Guantanamo outside the law and at the treatment of the prisoners in Iraq. In the 3 years since September 11th, President Bush and his administration have abruptly overridden rights protected by the Constitution and by our solemn international commitments. Ideas foreign to American beliefs, detention without trial, denial of access to lawyers, years of interrogation in isolation have become American practice. A system of carefully divided powers has been told that it must vest all power in the executive. Now, ladies and gentlemen, this is not the first time, and I don't want you to think I'm so naive or uninformed as to think it is the first time, that fear has had repressive consequences in America in a time of war or other tensions. At the very beginning of the Republic, in 1798, Congress passed and President Adams signed into law a Sedition Act that made it a crime to criticize the president. The stated reason for the act was the fear that French Jacobin terror would come to America. There were repressive excesses during the Civil War. In World War I, Woodrow Wilson's Justice Department sent people to prison for as long as 20 years for criticizing the draft and for criticizing Wilson. On Franklin Roosevelt's orders in World War II, 100,000 Americans of Japanese ancestry were taken from their homes on the West Coast and kept in desert stockades. But there is a worrying difference between those past episodes and the excesses of today. Soon after those earlier events, the United States regretted the abuses. Editors who had been convicted under the Sedition Act of 1798 had their fines repaid. We apologized formally in legislation to the Japanese Americans for their mistreatment in World War II and paid the survivors modest compensation. But this time, it is hard to imagine an end to the terrorist threat that has been made the reason for repression. Osama bin Laden is not going to do what the leaders of the Japanese Empire did at the end of World War II, board an American ship to surrender. And after Osama, there are terrorists in many places who are likely to carry on. So if we do not watch out, if we do not take care of the law, if we allow our government to put what it calls necessity above the rule of law, there will be no end in sight for the age of repression. What we must challenge is the notion that it is a form of weakness to respect the law. To the contrary, law is our strength and our redeemer. That is a theme sounded by a great figure in the world of law, the president of the Israeli Supreme Court, Aharon Barak. Given Israel's unending struggle against terror, Justice Barak speaks from experience when he addresses the question of terror and the law. And with his words, I'll conclude. Terrorism does not justify the neglect of legal norms, Justice Barak has written. This is how we distinguish ourselves from the terrorists. They act against the law by violating and trampling it, while in its war against terrorism, a democratic state acts within the framework of the law. It is, therefore, not merely a war of the state against its enemies, it is a war of the law against its enemies. Thank you.
Mr. Lewis has agreed to take some questions. There are 2 microphones, so if you would come to the mic, we can't see, of course, who's where, but address your questions to Mr. Lewis.
I'll put my hand up and try to see where hands are. Yes, sir.
You argued that the Bush administration lawyers who undermine the rule of law should not be called conservatives. Would it be reasonable to call some of them neoconservatives?
The neoconservatives in the administration have been more prominent in foreign policy, in particular in pressing for the war on Iraq, or in Iraq, than they have on the law side. It's very hard. I don't actually know whether the leaders of the Justice Department justifications for torture, for example, Professor Yu of Bolt Hall, Berkeley, Mr. Bybee, now a judge, or 1 or 2 lawyers in the Defense Department would call themselves neoconservatives. I don't know. They are something quite new to me. That is, lawyers who don't believe in the law, who think the law should be brushed aside, or who make excuses and explanations for why the law doesn't mean what it plainly says. So I understand the thrust of your question, but I can't answer it definitively. I think.
Yes, I think the whole idea of the war on terrorism is nothing but political, farce. The Israelis were called terrorists by the British government, and many countries have called their enemies terrorists. And I was wondering, how do you think Bush would define winning the war on terrorism?
Well, at one point he said, and then he was sorry he said it and took it back, that you can't win it, or he wouldn't win it. Well, I think that was a truish statement, because it's the nature of it that it's unending. You're right that governments have been very quick to say that opponents are terrorists. But despite that, and despite abuse of the term, there are terrorists. Osama bin Laden and company, Mohammed Atta and the others who knocked down the World Trade Center, they weren't anything but terrorists. Their aim was to create terror, and it's distinctive of terrorism. I don't know that I can give it a complete, totally satisfactory definition, but certainly its aim is usually not some discrete thing like a piece of territory or, something like that, but it is to create terror. And that, I think, there were terrorists. Whether it was wise to call it a war on terror, I don't know. It might have been better, some thought, and I was inclined that way myself, to deal with it as a criminal act and to use the criminal law abroad and at home against terrorists. But it's understandable that as a political matter, and I'm not critical about this of President Bush, he felt it necessary to rally the country at a time when it was shattered, people were really scared, and they were. They really were. In that, I don't think he can be faulted. And if it was necessary to call it a war on terror at that point, I wouldn't fault that. What I do think was wrong was the attitude that followed, typified by Attorney General Ashcroft's statement to the Senate Judiciary Committee that if you criticize us as violating civil liberties, you're on the side of the terrorists. I thought that was really an outrageous thing to say.
Yes, I was wondering if you were going to get to some of the abuses in previous wartime periods. We gave very brief lip service to the terrible abuses by Wilson and Roosevelt, and somehow managed to insinuate that they weren't as bad as Bush's abuses. I don't know how you can say putting 120,000 Japanese in concentration camps is not dozens of times worse than anything Bush's done. Also, we passed very briefly on what happened in Wilson's administration. Hundreds of German language newspapers were stopped being put through the mails by the Attorney General of the United States. And he said some people were put in jail for up to 20 years. One of course, was G. Victor Debs, who was a 4-time candidate for President of the United States, put in jail under the Wilson administration and pardoned by that bastion of conservatism, Warren G. Harding. And during World War II, that wonderful libertarian, Earl Warren, Attorney General of the state of California, went along with the internment of the Japanese, and J. Edgar Hoover was opposed to it. So how can you say that what Bush has done in any way compares to what Roosevelt and Wilson? Thank you very much.
I thought I went out of my way to criticize Roosevelt and Wilson, and I agree with all that you said about how awful it was. I've always thought the Debs case was one of the worst in our history. Debs had done nothing more than to express sympathy with two men near where he was speaking in Dayton, Ohio, who were in prison for consulting with potential draftees about how to avoid the draft. He just expressed sympathy with them in a speech largely devoted to the virtues of socialism. 10 years he got for that, and he ran for president the next time from a federal penitentiary. So I agree with you, what can I say? But we're living today. I wasn't making a comparison, I was talking about the threat today. And what's worse today, to me, is the endless quality of what we face, what's more dangerous. I think that was in the minds of the Supreme Court justices when they decided the Hamdi and Guantanamo cases as they did. It was somewhat surprising that they did, because the court has not been a bulwark of liberty in the past in times of war and national stress. It never passed on the constitutionality of the Sedition Act of 1798. It was supine in World War I, and supine again upheld President Roosevelt's shocking order about the Japanese Americans. The one thing you can say is that the case in which radicals were sentenced to 20 years for throwing leaflets critical of President Wilson from the tops of buildings in New York at least brought out the first opinion ever in the Supreme Court passionately invoking the importance of freedom of speech, and that was Justice Holmes's dissent. And I'll just quote as best I can one passage from it, which will tell you how I feel. First of all, he said that the American system of finding the truth through competition in ideas it is an experiment, he said, as all life is an experiment. I think there's no other justice of the Supreme Court in history who could have written that sentence. And then he said, we must be careful not to allow the suppression of opinions that we loathe and believe to be fraught with death. That's about as strong a statement of what we have to endure for free speech as you can imagine. That's what I believe, and I think the danger is very great now, not because anything as awful as the sequestering of the Japanese Americans has taken place, I agree with you, but because the potential is so great, the potential for the concentration of power in the hands of the president and the claim that the president can decide to torture people or do anything else in the teeth of a statute of Congress and a treaty that the United States has signed. That's a very far-reaching claim at a time when this emergency may go on forever.
Thank you, Mr. Lewis.
Oh, thank you.
Sir, I'm here.
Yes.
And the civil, for discourse to be legal, it helps if it's also civil and factual. And I'd like your thoughts about, I guess you might say, internet correspondence presently, urban legends, you might say, and then this tradition reaching back into the 80s and the beginnings of talk radio and sort of this free discourse on the airwaves, a lot of it that takes place after midnight, but some of the most amazing things that you can hear there. And if anybody hasn't tuned in, I recommend you do. But secondly, I'd like your reaction to the places that in our discourse in this country. Thank you.
It's a very interesting question. I want to tell you that I don't tune in to them after midnight because I go to bed at 10. But I try to anyway. I wake up early. But the serious thing is that is a phenomenon that's going to be with us from now on. It's very important. I agree with you. And we also ought to realize it's very painful at times. Somebody who's totally irresponsible, like Matt Drudge, can say anything he wants, true or false, a lot of it false, and there's nothing to be done. And a lot of people who are not even as, what should we say, tied to any reality as Matt Drudge is. But here's what to keep in mind. Those people, those voices, are doing exactly what James Madison expected to happen under the First Amendment. It's the closest thing we have come to the Madisonian ideal in our lives. Madison lived at a time when there were no great established newspapers or broadcast networks or established anything. There were little sheets, and you could put out a newspaper by going to a job printer and with some copy written out by hand, of course, and saying, print this, and how much will it cost? And he printed a sheet, and that was a newspaper. And the editors were very often in the pay of political parties. They were highly partisan. There was no such thing as objectivity in a newspaper, not expected, didn't happen. And that's what Madison thought should be protected. And he thought that out of this conflict, out of this maelstrom, would come some kind of truth. Now, you have to have a certain amount of faith to believe that, because sometimes it's very trying when you see things that are not true and that are devastatingly unfair and so on and so on. But that's the system, and I think we are just going to be stuck with it.
Thank you, Judge.
What indications have you seen, if any, that some of this disregard for the law by the Bush administration is targeting, rather than terrorism,
Is what?
Rather than terrorism, is targeting political dissent?
Well, there are some things that target political dissent. Some of them were mentioned this morning by people on the floor, I thought very wisely. For example, the refusal to let protesters, even the mildest protesters, get anywhere near President Bush when he campaigns. They're kept 2 or 3 blocks away so that he can't even see somebody holding up a sign saying something inoffensive but in disagreement. One of the questioners instanced the case of 3 teachers, registered Republicans, who were invited to a Republican rally for President Bush somewhere, I forget where, and wore T-shirts that said what? Something extremely mild, like keep the peace, or no, not even that strong. Say it again?
Protect our civil liberties.
Thank you. Protect our civil liberties. Well, you can't imagine anything sort of more like breathing in and out. What could be wrong with protect our civil liberties? They were escorted from the hall. They were regarded as disturbance. So, yes, there are some things like that happening. But I think, for me at least, they are not as menacing as the claim that you can torture people in the teeth of the law, that the president can override the law whenever he feels like it. That's really a shocking claim. Or the notion that you can imprison American citizens for the rest of their lives in solitary confinement without counsel and without a trial. Those are really sweeping claims.
I have a question, but first I'd like to appeal to someone, maybe in the control room, who has the ability to dim those lights so that you all could see us.
That's a fair point. How about it back there in the control booth? You think you could dim some of these lights? It's those. Yeah, that's better. Thank you.
It wasn't all difficult, was it? Phenomenon that has
I can just barely see you. You're rather an attractive young woman, right?
You know what I said that to me for years? There's a phenomenon that we're seeing that concerns me, and it's not new either. And that is what many people have called state terrorism.
It's called what?
State terrorism.
Yes.
In response to the terrorism of individuals and groups, the state engages in activities which might well be called terroristic in nature, intended to simply frighten, intimidate people. Now, this, of course, is often levied against what the Israelis do in the Palestinian territories, where they bulldoze entire blocks. It might also be applied to what we do when we bomb from great heights so that there will be many civilians caught innocently in this attempt to get at our terrorist enemies. My question to you is, what does U.S. law and what does international law say about this kind of terrorism, and how might that be applied to the present situation as well?
I think there undoubtedly is such a thing as state terrorism. Get to the bottom line, the Nazis certainly practiced state terrorism. But I think in general it's not very helpful, except as a term of abuse, to say state terrorism, because it's always going to be so debatable whether it is terrorism or whether it's a step that's needed to protect against terrorists, as you know, the examples you gave. When the Russians destroyed Grozny, the capital of Chechnya, were they engaging in state terrorism? You can criticize them without using that phrase, which opens, you know, debates about philology and definitions. And I'd say the same about the American bombing in, say, Iraq or in Vietnam years ago. If the American military feels that the only way it can deal with the situation in Fallujah in Iraq is to bomb, inevitably large numbers of civilians will die, and they do die. That can be condemned. I think it's wrong, without calling it state terrorism. I don't think it's helpful to call it state terrorism.
I think perhaps there has to be an intent to frighten people, to terrorize them.
I don't think that's the intent of the American military commanders in Iraq. I think they're using the means they have at their command, and that's why it's such a difficult war, and why it's, I think, so unwinnable, at least as it stands now, because the United States does not have the troops on the ground, or the skill, or the nationality, or the language, or the, you know, it's not equipped, shall we say, to fight house to house in a place like Fallujah. So it resorts to heavier weapons, and that creates more resentment and more opposition. It's a very difficult situation. I don't think it's state terrorism by any means. But should it be criticized? Is it unlawful? There are conventions against, and I'm not only not familiar enough with them to answer you definitively, but there are conventions against mass civilian bombing. Whether they would apply to a situation like that in Fallujah, I doubt, because there would be a reason for the bombing, even if many civilians were killed. It wouldn't be terror bombing, should we say. The example of terror bombing was World War II, when there was no accuracy in bombing at all on either side, and the Germans bombed Coventry to terrorize the British population, and bombed the East End of London to terrorize London's population. There weren't any military targets, it was to terrorize. And similarly, the British bombed Dresden, as recounted in Kurt Vonnegut's novel. Which novel was it?
Slaughterhouse.
Slaughterhouse 5, thank you very much, yes. So it goes.
Thank you.
Let's take two more questions. Let's take two more questions, one from each mic.
You talked about America being an example to the world with its written constitution. I was wondering, now that we've made these steps to break some laws, what do you see from the international community? Do you see other countries willing to do the same? What do you think the long-term effects of our actions are going to be?
That's a very thoughtful question and worrying question. I think there's a kind of divided answer. I think the British, or let's put it not the British, but the British government, which has been the closest supporter of the United States in Iraq. Tony Blair, the Prime Minister, has been Bush's closest advocate, companion in the effort, has done one thing a little similar, though by no means as sweeping as the things Bush has done. They have detained several dozen foreigners in Britain without trial, giving them the option of returning to their homes, which an option they don't take up because they're seeking asylum from the very places they've fled, they've left. So they're in detention without trial. Their case is now before the House of Lords, Britain's highest court, which extraordinarily, for the first time in history, had an argument. Usually they sit in panels of 3 or at most 5. 12 members of that court sat to hear this argument a few weeks ago. So they know it's terribly important. And hence, there's a little bit, you could say, in Britain that's worryingly the same. But mostly, the reaction, certainly in continental Europe, has been one of outrage at what's happening in the United States. It has done us severe damage in terms of admiration, respect. Indeed, there was a story in, I think, the Financial Times the other day, which I found amazing, that American products and institutions in Europe, like Coca-Cola and Disneyland, are running into a decline in European customers, which some trace to antagonism to American policy.
I have a question.
If President Bush loses the election next Tuesday, do you think the current American policies towards terrorism that you just talked about will change, and if so, how?
I think very much will depend on who the next Attorney General is. I think John Kerry, if he's president, will have very likely, almost certainly, a Republican House, very likely a Republican Senate. He'll be under political attack all the time. Any change in things that I've criticized will immediately be attacked as weakness on terrorism. We all know that. So it'll be a hard slog. But I think a strong Attorney General would make a decisive difference in those practices. As I think today, if there were a different Republican Attorney General, it would be different. If it weren't John Ashcroft, I'll give you my sample. I have my hero, and that is President Ford's Attorney General, Edward Levy, who had been the Dean of the University of Chicago Law School and the President of the University of Chicago. He was a very conservative man, but he was a conservative who believed in the Constitution and would not have done any of these things. He simply would have said, you know, we're going to fight terrorism, but we're not going to fight it by changing American respect for law. And there is, I think, a real hope of that happening. I hope I'm right.
Thank you, Mr. Lewis.
Thank you.